Hello, my name is Charles Ward. I'm a staff attorney for Alaska Legal Services Corporation. And today we're going to present a video over landlord and tenant, both their rights and their responsibilities under the law. So we will start off with what a landlord's responsibilities are, beginning with a security deposit and prepaid rent. A landlord for security deposit can only charge at most twice what the amount of monthly rent is. However, if the rent is more than $2,000 a month, this limitation does not apply. So if you have a case where you're representing a tenant and the tenant's paying $1,000 a month in rent and has been charged a $5,000 deposit, then part of your remedy right there would be to go after the excess portion of that deposit. Landlords are only allowed to apply the security deposit to certain things. First off, being unpaid rent. The lease is over, everybody's moved out, but the client didn't, or the tenant didn't pay his last month's rent, or didn't pay 2 months worth of rent, or whatever it may be. That can go towards unpaid rent. It can also go towards damages. If there's any damage to the apartment that, or the unit that was caused by the tenant, that can go towards that. However, damages are not just every little scratch and ding in the house, because normal wear and tear is not considered damages. For example, carpet. If you have a unit where a client has lived for, say, 7 years, it's to be expected that that carpet is going to be worn and beat down and may need replacement. And that's not because the tenant has done anything to it. It's just carpet has a shelf life. It has a life that it has before it wears out. Another issue may be paint. Paint only lasts so long before it's ready to be replaced. So some of those things may be because someone has been on that, but not necessarily damages, at least not as contemplated by the law. It's also not damage if the landlord has failed to prepare for expected conditions, such as cold, heat, rain, wind. It gets very cold here in Alaska in the winter. And if the house isn't properly protected against the cold, then that is not going to be the client's fault when and if there is an issue that's related to the cold, such as a frozen pipe or something like that. And also, if the landlord fails to comply with statutory responsibilities, which we will continue to cover in the rest of this video. The landlord is supposed to keep the rent and security deposit in a trust account. Now, that doesn't mean he can't commingle those funds with other tenants' prepaid rent and their security deposits. He can. He doesn't have to have a separate bank account for each person. However, he needs to be able to separately account for all of those. So he needs to be able to say, the Smith family provided this amount as prepayment, and the Jones family provided this amount as prepayment. Landlord cannot use those funds he must keep those in a trust account. And there we go, covering the fact that they do need to be separately accounted for. Landlord can't use those funds to cover another tenant's rent, deposit their refund. So if one tenant moves out and wants their refund deposited, the landlord can't go to another tenant's funds to make that return. So obviously you may not find that out till after the lease is up, and then the tenant goes to the landlord and says, hey, I want my security deposit back, and the landlord doesn't have any money to pay it back with because he's used it for other people's pay off their rent or damages. Another thing is you can't use that money to pay for another tenant's damages. That may be something you see where tenant A has left the apartment and has caused significant amount of damage, so much so that the landlord doesn't necessarily have the funds to repair it. So he dips into the trust account, and the next tenant moves out and says, I want my security deposit back, and they've left the apartment in good shape. And the landlord doesn't have those funds because he's used that to pay for another tenant's damages. That's not something he's allowed to do, and your tenant is entitled to recover those damages or recover that security deposit. If there is a change of ownership of the property, if it's an apartment building and Acme Rentals sells it to Best Rentals Incorporated, the new owner is bound by these rules. Now, the rent deposit accounts would need to be specifically assigned in the sale contract to the new landlord. Otherwise, the old landlord would still be on the hook for paying those deposits back. That's typically not understood to be an issue. Either they get transferred and everybody understands that, or the landlord will simply just refund it as part of the sale, and you make a new arrangement with the new landlord or owner. So there you go. The new prepaid rent has to be expressly assigned to the new purchaser. So when it comes to refunding the deposit, if the landlord knows he or she will not use any of that deposit to pay damages, back rent, what have you, he or she has 14 days to issue that refund. Generally speaking, though, landlord, if he or she is going to use any portion of that deposit to fix damages, pay back rent, he then has 30 days. And generally speaking, a landlord may not know in 14 days whether he or she is going to have to use that deposit or not. So a lot of times landlords will take that whole 30 days to issue the refund. And the likelihood of being able to get a court to require them to issue it any sooner than that, being able to even get into court for that issue probably wouldn't happen in that 2-week period there. So a lot of times landlords, even though they will end up giving the whole deposit back, they will take up to that whole 30 days. The landlord also has 30 days to issue the refund if the tenant doesn't give proper move-out notice. Tenant, if you're month to month or at the end of the lease, you're supposed to give 30 days notice. It's week to week, it's 14 days notice, and should be in writing. If the tenant doesn't do that, then the landlord still has that 30-day period to refund any part of the deposit he or she is required to. The tenant is supposed to provide the landlord a forwarding address for either that refund or a list of damages that the landlord is using to offset that deposit. However, if the landlord doesn't have that forwarding address, but he or she still has the responsibility to take reasonable steps to try to track that person down. So if you have your former tenant's phone number, if you know where your former tenant works, you can make outreach those ways. Ultimately, your old tenant should provide a forwarding address, but if he or she doesn't, and the landlord still has a way of trying to get a hold of that person, the landlord has a responsibility to at least make the effort. Pets. A landlord is allowed to charge an extra amount for a deposit for pets. That extra amount can be up to 1 month's rent, but the landlord can only use that deposit for damage directly related to the pet. So there's urine stains on the carpet, or there's claw marks on one of the walls, or any of the sort of things a dog or cat or whatever pet might be can or can't do. It needs to be directly tied to the activities or the actions of the pet. Landlord has a primary duty to maintain a fit premises. Landlord must do everything under the law that's required to keep the premises in a fit and habitable condition. Well, the obvious question then is, what does that entail? So the landlord is obligated to make repairs. Now we'll get into some exceptions of these here in just a little bit, but as a general rule, these are the landlord's obligations: to make repairs to the property, keep the common areas clean. So if you own an apartment building with a common hallway or a common courtyard or what have you, it's ultimately the landlord's responsibility to keep those common areas clean or make sure they're clean. Maintain all facilities and appliances. So that is making sure the heat works. Air conditioning probably would not be determined to be an essential thing you would need in Alaska, but the heat certainly would be. Need to make sure that there's access to electricity. Need to make sure that there's access to running hot and cold water. Doesn't mean the landlord has to pay the utility bills on those things, but the landlord does have a responsibility to make sure that the tenant has a way to access those essential services. Also covers appliances that came with the apartment or that would be understood to come with, normally understood to come with a housing unit. So the toilets, for instance, or if the unit comes with a stovetop, usually probably can be considered a required way. The tenant would at least have to have some way of preparing meals. Refrigerator, maybe yes, maybe no. Usually most rentals have a refrigerator when you move in, and if they do, the landlord probably is going to be responsible for making sure it works. But certain other things that are not necessarily, that the landlord is not necessarily required to provide, maybe not a microwave oven, for instance. If it's part of the lease that it's going to be in there, it's understood that that's part of what the landlord is giving the tenant when they move in, then the landlord probably does have a responsibility, but he doesn't necessarily have the responsibility to give the tenant a microwave oven or a second freezer to store fish in or something like that. We talked about these. These are some of the facilities that need to be maintained: electrical, plumbing, sanitary, which again is going to refer to toilets, heating, and ventilation. And again, if some of these things may not be required under the law, but if they're provided as part of the rental, either under the lease or tenant moves in and it's understood that this is part of what he or she is getting as part of the rental, then they would need to be maintained or replaced if they break down. Again, air conditioning is probably not going to be considered essential in Alaska unless there's some reason that the tenant is in a unit that would just absolutely need it. But again, if it's provided when you move in, then you would need to offer that to repair that should it stop working. Certain things in the kitchen, like we discussed with a refrigerator, maybe a microwave oven, not essential, but again, if you provide it as part of the move-in, then would need to be maintained. Elevators is one specifically mentioned. If it's an apartment building that's 5-6 stories tall, and the landlord there's an elevator when they move in, and it's understood that there's an elevator as part of the entire unit, and that's how you get from your car to your 5th floor, then the landlord would need to maintain that elevator as well. Of course, the landlord's not required to provide an elevator necessarily. Some of that's going to depend on building codes and things like that, but even if they're not required to provide one, but they would provide one as an understood part of you living there, they would need to maintain it. And again, other items is provided in the lease that the landlord may provide. Landlord is required to provide trash receptacles. So it doesn't necessarily have to take trash out for the tenant, but the tenant has to have a place to put their trash. The landlord needs to make sure the tenant has access to running hot and cold water. So again, there's going to be an exception that we're going to talk about here later on regarding to dry cabins, but generally speaking, it's going to be an obligation to provide at least access to running hot and cold water. Landlords provide locks and keys. The locks need to be adequate to provide safety for the tenant, to provide safety for their belongings. So probably on outside access doors, maybe especially like the front door may require a deadbolt. Certainly need to be ways that are not easily overcome, or a lock that really doesn't provide any protection that a lock is supposed to provide. I skipped one real quick. Let me see if I can get back to it. But smoke detectors and carbon monoxide units. The landlord is required to provide those as well, and make sure the landlord's required to provide those, and they need to be working at least when the tenant moves in. There's some certain exceptions to these requirements. If it's a 1 or 2 family unit, if it's a rural area where utilities have never been hooked up, the example here that we talked about before would be dry cabins. Now, if a unit was in a rural area, but then that rural area gets water, or the cabin is hooked up to water, and then that water access needs to remain. The landlord can't say, well, at one point this was a dry cabin, but we added water to it, but now we're going to take that water out. That won't work. It has to be some area where you've never had utilities. If the rent is more than $2,000 a month, again, just like with a 1 or 2 family unit, some of these duties are assignable within the lease if it's a 1 or 2 family unit, so a house or duplex, or if the rent is more than $2,000 a month. If you're renting a home, for example, the landlord can probably assign the fact that you need to provide your own trash service. You need to keep your own yard mowed. You need to keep your own sidewalks clean, something like that. So if that's a house, then some of those duties may be assignable. You can also enter into a separate agreement to make repairs. Now, the way this works is it's not part of the lease. It has to be a separate writing from the lease, and it can't be a condition of the lease. But what you can do is say you have a lease that the tenant is obligated to pay $1,000 a month for. They can have a second separate agreement that says the tenant is going to make certain repairs to the property, certain upgrades, and in exchange for those repairs or upgrades, the rent would be reduced, or the landlord would simply pay the new tenant a fixed rate to do those things. So there you see, it cannot be a condition of the lease, so it has to be separate. And there also has to be adequate consideration. Now, of course, adequate consideration is obviously going to be very fact and situational specific, but it can't be a illusory consideration. Landlord has a duty to disclose. Landlord or his or her agent must disclose the name and the address of the property manager and either the owner or the owner's agent. Now, for small properties, one house, something like that, these are all probably going to be one and the same person, or very likely could be. For a big property, maybe 150 unit apartment building that's owned by a big corporation, the owner is probably going to have an agent. So they need to be able to know who to contact in case there's an issue with the property. Also need to be able to know who the owner's agent is to contact if there's an issue that would normally require the owner's attention. So disclosures have to be kept current. If the property manager changes, you need to let the tenants know that so-and-so is no longer the property manager, this person is the property manager, and this is how you get a hold of this person. Same thing if there's a change in ownership. If a person required to make a disclosure doesn't, then that person becomes an agent for service of process and the responsibilities of the landlord. This may be something like someone who is in charge of showing and renting the units to somebody, but isn't in charge of the property and the owner doesn't intend this person to be their full representative. But if the person doesn't make those disclosures and should, then that person is going to be considered an agent when it comes to process service. And also, if the landlord has failed on one of its responsibilities, they could be liable for that failure. Special rules for mobile home park owners. They need to disclose if a tenant has to make capital improvements such as skirting of a mobile home or has to provide their own utility hookups. One of the landlord's primary duties is to actually supply possession of the property. That means you say that the lease starts January 1st, that house or apartment or what have you needs to be ready to go and be able to move in. If you don't supply then the tenant can then the tenant has remedies that we've talked about or we will talk about in a different recording. Tenant has responsibilities. Primary tenant responsibility we just skipped over, and unfortunately I cannot get my slide to go back, but the primary duty of a tenant obviously is to pay rent. That's the whole reason the arrangement exists. The tenant has the responsibility to occupy the premises, use it as a dwelling, maybe some small certain, if they have a Etsy store and they work on their arts and crafts at their house, that's probably not enough to say that they're not using it primarily as a dwelling. But if they're a doctor and they're seeing patients there, or if they're running some other kind of business operation there, and that's really the reason they're there, or that's a large part of the reason they're there, then they're not really using it as a dwelling. And there may be, in addition to that, the tenant not living up to their responsibilities, the lease probably has provisions preventing them from doing certain things, and city or borough ordinances may also prevent them from doing certain things in property that's not zoned for business. When they occupy, they also have an obligation not to abandon. It means just take off without notice. When you move out, you generally have to give 30 days notice. Certain situations, it's 14 if it's a week-to-week rental, but otherwise you need to give 30 days notice that you're going to move out. And that notice has to be either at the end of a lease or in a month-to-month situation. If there's a lease, the tenant's obviously obligated to live up to his or her obligations under that lease, which includes paying rent and occupying the premises for a set period of time. Abandonment also includes leaving the property unoccupied for more than 7 days without notice. So tenant goes on vacation, goes down south for a month, goes on down south for 2 weeks. They need to let the landlord know that's what's happening. This isn't a case of the tenant asking the landlord's permission to do this. It's not like the landlord can say yes or no, you can or can't do this. But the tenant does have an obligation to make the landlord aware so that the landlord knows that there's not going to be anybody in the house for this period of time. The tenant hasn't abandoned it. The tenant tends to come back. And so the landlord can go by and maybe once or twice while the person's gone, check on it, be sure there's no issues that you would normally see if you were living in the place for on a regular basis. Tenant has an obligation to keep the premises clean. I mean, take out the trash. Make sure you don't have big pileups of trash. Usually, if it's a big apartment building, there's usually a place to put the trash. If it's a house, usually the landlord will either have waste service set up, or the tenant may be responsible for having to do that service depending on what kind of house and the amount of money that's available or that's being paid in rent. It needs to clean plumbing fixtures. This doesn't mean the plumbing itself, but sinks, toilets, bathtubs, showers, things like that need to be cleaned so there's no mildew, so there's no other effluvia that might be part of using those facilities on a regular basis. A tenant has a responsibility to keep the premises safe. Again, this is going to depend on one, what type of premises it is, and two, whether some of these duties have been assigned to the tenant or not in the lease, and then whether the landlord has the legal right to assign some of those duties. But it's the same. You can't have. There may be provisions that require the tenant to make best efforts to be sure there's no ice on the walkways. Tenant may be required to not have hazardous conditions in the house, what have you. At a minimum, he has to notify the landlord of unsafe conditions. So if there is a problem that's making the unit unsafe, the tenant does need to notify the landlord that that's going on. And of course, depending on the lease and the type of house it is, tenant may have other responsibilities. Tenant has the responsibility to use the appliances and facilities in a reasonable manner. This means don't use the stovetop to cook meals. Don't use it to make crayons, or use it to make some illegal drug. Don't stop up the showers for some reason. Don't drop cherry bombs down the toilet, what have you. You're supposed to use the appliances and the facilities as a reasonable person would do so. They have a responsibility not to cause damage. This is damage, of course, beyond normal wear and tear. Not punch holes in the walls, not spill stuff on the carpet, not do these things. If they do cause damage, they're obviously liable for that, either at the time the damage is caused or when they move out. If the damage is intentional, and the landlord can show that it's intentional, the landlord would have grounds to terminate the lease. This also applies to a tenant's guests. So if a tenant has guests over and the guests cause damage, whether it's intentional or unintentional, it would be the tenant's responsibility to remedy those things. Not cause a nuisance, so no loud parties, no drug use is kind of a tricky issue, but certainly would not want it to be open and notorious. So much so that the police are being called to the residence as a result of the drug use, or the neighbors are somehow affected by that drug use. This again also applies to guests. Not engaging conduct that would draw a municipal fine. So if the tenant has a responsibility to keep the lawn mowed, he or she needs to do that. Again, no loud parties, certain restrictions perhaps on uh, fireworks, for instance, something like that. This all again also applies to a tenant's guests. Uh, Not have more people living in the unit than the law or the lease allows. The lease should specify how many people are living in the unit, and if that's going to change, there should be a written addendum to the lease. Certainly, the law, obviously, building codes and zoning codes and what have you, are going to limit the number of people that are allowed to live in a house as well. So, if for some reason there isn't a written lease, the law would limit the amount of people just based on zoning codes and building codes, things like that. Tenant's responsibilities: don't engage in criminal conduct on the premises. This would also apply to guests. The Landlord Tenant Act lists specific crimes, but it's not intended to be an exhaustive list. These are just examples that are in the Landlord Tenant Act. Don't run a house of prostitution. Don't run the premises as a house of prostitution. Don't serve or consume or make illegal alcohol or illegal drugs. Don't run a gambling hall in the premises. Some of these things are going to be fact specific and situational specific. If a client has a friendly home game, if a tenant has a friendly home game of poker that's low limit, that's probably not going to be enough to become criminal conduct such that they're in violation of the lease. But if they've got blackjack and $100 a hand going on, that's probably going to be enough to consider it that. And again, that's not an exhaustive list. Those are just some of the examples listed in the statute. Tenant has responsibility to leave the property in substantially the same condition in which it was received in. Now, the exception, of course, is normal wear and tear, which we've discussed. And if the carpets were professionally cleaned prior to the tenant moving in, then the tenant can be made liable or responsible for having them cleaned before he or she moves out. That's not necessarily always the case. Typically, the standard is what's called broom clean. But if carpets were professionally cleaned and it's obvious that they were, or there's an understanding that they were, then the tenant probably is going to be responsible for having them professionally cleaned before moving out or as part of the move out. So those are the responsibilities. Now we'll get into a little bit of what happens if either the landlord or the tenant doesn't live up to their responsibilities. Landlord has a right to require premises condition and content statements. This would be something you would sign at the at the start of the lease. Should be separate. So the premises condition list or statement, sorry, and the content statement should be separate. Premises statement is going to discuss things like fixtures, things that are going to stay with the house whenever the tenant moves in, moves out, things that are part of the house or the apartment or what have you. Also, will list the condition of the premises on move-in. So if there is a hole in a wall somewhere, or if there is a stain on the carpet, or if the carpet is already worn and kind of threadbare, that should be noted on the condition statement, so there's not an issue when the tenant moves out. If it's a condition that doesn't really materially affect the health, welfare, and safety, and the tenant is okay with it, then it just needs to be understood that the tenant's not going to fix it, and they're not going to be responsible for fixing it because it was that way when they got there. Content statements are just that. Again, they become part of the rental agreement, but the content statements are simply going to cover things that are in the house that are not necessarily fixtures, like if it's a furnished apartment or other things like that. They do become part of the rental agreement, and they can be used as a basis for retention of security deposit or charges for damages. Hey, the conditions, the premises statement didn't list this big hole that's been obviously burned into the carpet. I'm going to charge you for that. It didn't list this big hole that's been punched in the wall. I'm going to charge you for that. And if there is a court case, it does create presumptive evidence of the condition of the premises at move-in. Landlord has a right to establish rules under reasonable conditions. They need to be reasonably related to the tenant's convenience, safety, health, or welfare. And this isn't just the tenant that is perhaps breaking the rule. This is all tenants. So rules need to be geared towards those tenants' convenience, safety, health, or welfare. They also have to be reasonably related for the purpose to which they are adopted. So it would be probably reasonable to say that you have to, it may be reasonable to say, hey, you have to sweep your porch. It may not be reasonable for you to say that you have to sweep sand and paint your porch. They must apply equally. So if one tenant has a responsibility to do something, all the tenants in the unit must have the same responsibility. So if it's a big apartment building, you can't just say one tenant has a responsibility to do certain things, but another tenant doesn't. Now, of course, this may be different because obviously different apartment units are going to have different configurations. And if one, say, has a jacuzzi tub in it and the other one doesn't, both tenants obviously can't maintain a jacuzzi tub or do certain things that they have to do for a jacuzzi tub. They must be clear. So can't really be ambiguous as to what you're supposed to do, what you're not supposed to do. And they must be given to the tenant when signing the lease. You usually probably have the tenant sign a separate rules document. Now, of course, circumstances do change. And if they do, you as a landlord can change the rules if they meet these other requirements. They're reasonably related. They are for the health, safety, welfare, or comfort of tenants. They're clear, and you give adequate notice that this rule is going to change. So you need to post it, send everybody a letter, give everybody a phone call, what have you, make sure that they have a reasonable amount of notice and probably a reasonable amount of time to, I guess, for lack of a better word, get used to the new rule. And the new rule can't substantially alter a rental agreement. Can't get too far into that because that's going to be very fact and situational specific. But just know that that's something that cannot be done. And the rules cannot shift the landlord's obligation onto the tenants. So again, we talked about some of the things that are landlord's responsibilities. If the landlord wants to, could have shifted an obligation to the tenant in the lease, but didn't do so, landlord can't go back and say, well, I'm going to create a new rule. It won't work that way. They would need to enter into a new lease agreement, or the landlord's kind of stuck until the end of that lease. A couple things special for mobile home parks. An owner can require a tenant install certain equipment. We talked about skirting, utility hookups, certain other things, but you can't require that the person buy this from a particular vendor. So you can say you need skirting, but you can't say you need Acme skirting that's green or black from Bob's House of Hardware. It has to be, the tenant has to have some discretion in what they install. Landlord has a right of access. So the main qualifier on that is that it has to be reasonable. They can do it for inspection, repair, supply services. So if the landlord is obligated to fill a pellet heater, for instance, they can enter the property reasonably to do that from time to time. Or remove the landlord's personal property. That sometimes happens at the beginning of a lease. Landlord's been working to get the lease ready to go and realizes, hey, I left my ladder over there, I left my tools over there. Landlord can call out, can give notice, say, hey, I'm going to come get this stuff. And that's perfectly within the rules. Showing the property prospective tenants or purchasers. So landlord's getting ready to sell the property, or the lease is coming to an end and the landlord and tenant aren't going to renew the lease. Landlord has a reasonable access to show it off. Also to let workers or contractors in. Despite having a right of access, landlords must still get permission to enter from the tenant. Now, some of you may be saying, well, if they give notice, why can't they just enter? To avoid violent confrontations or misunderstandings, the law still requires the tenant to give permission. If the landlord's access is otherwise reasonable, but it's still without permission of the tenant, the landlord can still be liable for that. And the landlord's remedy at that point is to go to court and get an injunction requiring the tenant to provide access. Some of the elements of reasonable access: 24 hours notice. Now, if you don't give 24 hours notice and the tenant's otherwise okay with it, then that's not a problem. But otherwise, you would generally give 24 hours notice. Again, covering what a landlord can do to gain access if the tenant denies it. Landlord can't just force his way in, can't just use his key to get in the door. He has to obtain an injunction if the tenant refuses access. He does have remedies to be able to sue for damages if he's denied access, if there are damages because the tenant didn't allow access and the landlord couldn't fix a problem or what have you. And he can sue for 1 month's rent or actual damages, whichever is more. So landlord doesn't have to give notice in case of emergency, and that should be pretty obvious to anybody. If the house is on fire, the landlord can go in to help try to put it out. Or if the house catches fire, and the fire department has come and put it out, the landlord can come in to give them access to certain rooms so they can check the place out. So obviously, and a reasonable tenant obviously is not going to want to wait for the landlord, does not want the landlord to wait for them to call and get permission to go in if there's really a true problem. If there's a court order, we talked about getting injunction to provide access. In the court order, of course, the order probably is going to spell out when the landlord can access and probably provide a writ of assistance, which means the police will come help if need be, or if there's abandonment. So if it's obvious that the tenants have just taken off and moved on, they go in, the landlord looks at the house and there's no furniture there. The house is empty. Or if the landlord, it's obvious the tenants haven't lived there for more than 7 days, the landlord can enter, make sure the property is okay, and try to understand what exactly has happened. Of course, if the landlord decides that the things have gotten so bad that they need to seek a lawyer's help or maybe do it on their own, they do have a right to sue a tenant for certain things. First off, material noncompliance with rental agreement. That is most obvious case of that is not paying the rent. But obviously could be other things as well that are laid out in the rental agreement, and provided that they are legally in the rental agreement and the tenant's not living up to his or her responsibilities, the landlord can sue for that reason. Non-payment of rent, the landlord must give a 7-day notice to cure or quit. Basically, landlord has to post a notice. And again, I'm not going to go too far into what a notice to quit actually has to contain or not contain, because we have a separate training on that very topic. But generally, the first time a tenant misses the rent payment, they have an opportunity to cure the problem. Basically, they have 7 days to fix the problem, pay rent. Otherwise, they also have notice that they need to get out. The lease automatically terminates if the tenant doesn't pay or move within 7 days. Of course, the landlord can re-up the lease if they can come to some kind of arrangement on the rent. Deliberate infliction of damage. So obviously, if someone's there punching holes in the wall or what have you, and it's obviously deliberate, then the landlord can just give a 24-hour notice to quit. And since the damage is deliberate, there's not an opportunity for the tenant to cure the problem. Negligence, maybe there may be an opportunity to cure, but if it's deliberate, no. And the infliction of damage, the deliberate infliction of damage has to be more than $400, which is in this day and age, particularly, is not really that high of a bar to clear. But we need to know that we're not just talking about putting nail holes in the wall. Same thing with illegal activity. If there's illegal activity going on, you can give your tenant 24 hours notice. They don't get out, you can go to court and get it to seek possession. Again, if there's illegal activity, the landlord doesn't necessarily have to give an opportunity to cure the problem. If you're running a gambling hall there and the landlord finds out, landlord can say, hey, you got to get out. Other non-compliance with the rental agreement that's not related to non-payment, that generally requires a 10-day notice to cure or quit. Usually the tenant will have an opportunity to cure the problem. There's some violations that are so egregious that a tenant is not going to be given an opportunity to cure. One example that there's a case law about is the tenant would walk around in the nude in sight of all the other tenants of the property and things like that, and would do it wasn't a one-off, would do it repeatedly and knew he was doing it. the landlord didn't have to say, hey, stop, or else I'm going to give you a notice to quit. The landlord can just go straight to notice to quit. And if it's the same non-compliance twice in more than 6 months, so if it's an issue saying, hey, the tenant's not taking the trash out like you're supposed to, okay, the tenant fixes the problem once, but then 2 months later, it's a problem again. Well, then the landlord doesn't have to give an opportunity to cure. A lot of these, what notice is required, how much notice, and whether the tenant has an opportunity to cure quit are going to be very fact specific and specific to your case. So, and again, this isn't intended to be a broad seminar on notice to quit. There is another seminar or recording that's out on that issue. Also, if the tenant has utilities disconnected and because they haven't paid, obviously a landlord has interest in the tenant maintaining utility service, because failure to maintain water or heat during the winter can cause pipes to freeze and break. So that's obviously just one example. There's obviously a landlord has interest in making sure the tenants are paying for and using utilities as they're supposed to. In that instance, you would give a 5-day notice to quit, and the tenant would have 3 days to either reconnect the utility, or if the landlord has gone in and paid it so that the landlord doesn't suffer damage to his or her house or apartment unit, then he would have 3 days to repay the landlord for that, for the landlord's reconnection. If there has been a utility disconnect and there's damage to the property because of that, then the landlord can still go ahead and terminate the lease, doesn't have to give the tenant opportunity to cure the problem. Also, if the same utility has been disconnected twice in 6 months, guy's having a problem paying his water bill, guy's having a problem paying his electric bill, what have you, you can just go ahead and terminate, and you can do that on 3 days notice. Abandonment. So the tenant just ups and leaves, and you don't know what has happened or why they've left, but they didn't give notice, and there's no indication that they had another rightful reason to leave. So if they're abandoned for more than 7 days without notice, now obviously a reasonable landlord, if he thinks it's been abandoned or knows it's been empty for more than 7 days, is probably going to try to call a tenant and say, hey, what's going on? But more than 7 days without notice would be considered abandonment. And there would have to be clear signs of abandonment to be able to enforce a lawsuit based on abandonment. They've taken all their possessions and gone, what have you. If there are damages, landlord again can sue for 1 1/2 times the damages if the property is abandoned. So obviously one of those things would be non-payment of rent that he expected. Landlord would have a right or a obligation to try to fix that problem and re-rent the place, but any damages he incurred while he was taking to do that, or if the abandonment led to damage of the property, that would normally have been seen by a person who was living there ordinarily. If the landlord accepts rent, when the landlord knows the client is in breach and landlord accepts the rent, then you've waived the ability to terminate for that breach until the next rental period. So you don't have to keep entertaining the breach, but if you got a problem with a tenant and the tenant is saying, hey, I'll fix the problem, and the landlord wants to give the person a chance, he can, but that gives them until you can't go back and then say, I'm going to terminate the lease. Or if you know there's a problem and you don't say anything to the tenant about it. But that doesn't, the landlord doesn't have to endure that breach for all time. It's from rental period to rental period. Landlord cannot engage in self-help. What do we mean by self-help? Locking the tenant out of the property, shutting off the utilities deliberately, taking the tenant's property out of the property and throwing it on the front yard, or putting it in a storage shed or something like that. Landlord cannot retaliate. So if a tenant either says, hey, I've got a problem here, and the landlord doesn't want to fix it, or tenant says, hey, I've talked to a lawyer and this is a problem, or if the tenant calls like the municipality of Anchorage or a borough authority and says there's a problem with the landlord here and there's a code violation, landlord can't turn around and retaliate and say you're out. So the tenant. Tenant's main right as a tenant is the right of quiet enjoyment. Basically, if they're following the rules and paying the rent on time, then they have a right to be left alone. That's from both the landlord. Of course, the landlord has a right of reasonable access, but again, it has to be reasonable. Landlord can't say, I'm going to come in 3 times a day. That's not reasonable. Landlord has to give notice. Landlord can't come in at 3 in the morning unless the landlord specifically has permission to do that. But also right to peace and quiet, including from neighbors. So if it's a big apartment complex and there's an apartment that throws loud parties 5 times a week, the landlord has an obligation to do something about it, because the tenant does have a right of what's called quiet enjoyment. Right to adequate safety measures so that they have reasonable assurance that their stuff is not going to get stolen or someone's not going to come in and do harm to them. So the locks, keys, whatever may be reasonable under those circumstances. If it's a big apartment building, perhaps there needs to be extra security measures so that tenants or people don't get in who aren't tenants or guests or don't otherwise have a reason to be in the building. Right to access to basic utilities, electricity, heat, running hot and cold water, unless there's a dry cabin situation or something like that. You have a right to recover your security deposit. If you have done everything you're supposed to do at the end of a lease, you've given notice, you've moved out, you haven't left anything, you haven't left a bunch of junk behind, you've cleaned the apartment, cleaned the house, and turning it back over basically as you receive it, then you have a right to get your security deposit back. If the landlord willfully and wrongfully retains your security deposit, then you are able to sue and recover up to 2 times your actual damages. So if you've given $1,000 security deposit, you move out, the place is in great condition, and the landlord still won't return your security deposit, then you can sue and recover not just $1,000, but $2,000. A tenant, if they're living there and the landlord is not living up to his or her responsibilities, the tenant can issue that landlord a written notice of noncompliance. It's got to provide a description of the problem. It's got to give the landlord at least 10 days to fix the problem. Now, there's probably going to be a reasonableness thing put here. If there is a pipe burst and it's filling the house with water, the landlord probably has an obligation to do something faster than 10 days. Now, it doesn't necessarily have to fix the whole thing, but at least has to shut the water off or shut the pipe down or what have you, so that the house isn't getting more damage, or the tenant, more to the point for the tenant, their property isn't suffering further damage. If the landlord doesn't fix the problem, then the tenant has some choices. The tenant can terminate the lease in 20 days. So they give the notice January 1st. Problem isn't fixed by the end of January 10th. The tenant can then say, hey, I'm out of here, and I'm out of here on the 20th. So you don't have, it's not 20 days after that 10-day period passes, it's 20 days after the first written notice is given. And just like for a tenant, if the tenant commits the same issue, has the same issue twice in 6 months, the same thing applies to a landlord. If the tenant can now terminate on 10 days notice and doesn't have to give the landlord a chance to fix the problem if it's the same problem that reoccurs within 6 months. You can sue a landlord for an injunction. The landlord is not doing what he's supposed to do. Tenants don't always have it's not always a simple matter for a tenant. In fact, it usually isn't, particularly nowadays, for a tenant to just up and leave. Moving is expensive. It's a tight housing market right now. So the tenant, instead of saying, hey, I'm going to move, may say, hey, look, I need you to fix this thing. You're supposed to fix it. It's your responsibility to fix it. So they can go to court and then seek an injunction that would require the landlord to address the problem. You can also sue for damages, which includes diminution of rent value. One drawback to this is it can be difficult to put an exact dollar value on how much the unit's rent value is diminished. Sometimes you can, but it's not always an easy thing to do. Failure to deliver possession. Lease is supposed to start January 1st, and you show up at the house and landlord's not there to give you the keys. It looks like someone else is living there. Landlord hasn't delivered possession. The tenant now has a right to withhold the rent until the landlord actually delivers possession. if it's an issue of, hey, something came up and I needed 1 or 2 extra days to get the house ready to go, tenant can be like, okay, I'll give you 1 or 2 extra days, but he's not going to be obligated to pay the rent while the landlord's fixing that problem up. Tenant can also just terminate the lease. Say, hey, I was supposed to move in January 1st, and I obviously couldn't move in January 1st. I'm giving you 10 days notice, and I'm terminating the lease. The tenant's going to be able to recover their security deposit and prepaid rent in that instance. And there really wouldn't be a reason for a landlord not to provide it back in 14 days in that instance. Landlord can also go to court and sue the landlord for possession and require the landlord to turn possession of the property over. So the tenant can say, hey, I've got a lease. I can go to court and say, I've got a lease. The landlord's not providing me my apartment or my house. You probably would not see this very often, because if it's really a true problem that can't be remedied in a day or two, usually the parties don't want anything to do with each other, and they sort of don't want to live together or have to have a business arrangement for the next year. But it is an option. You can also sue for damages. So that would be an issue. You have to find a hotel until you can find a new place to live. The moving company is going to charge you extra because they went to the place and then they had to go to another place, or they had to store your stuff for 10 days, what have you. If it's willful, the tenant can sue for 1 1/2 times damages. Again, willful is going to be kind of fact specific, but just wanted to make that aware that is an option. If landlord fails to provide essential services, this is going to be, again, heat, running hot and cold water, sanitary facilities, electricity, proper ventilation, certain other things that are considered essential. I mean, you've got to have these things for a house to work, or an apartment to work. So the tenant can go on and procure those services themselves. So if they can find access to some of these facilities, or they can go flip a switch and the power is on and they can do those things, and if they enter any costs, they can deduct the cost from the rent. Again, recover damages for diminution of rent value. This one is actually a little more favorable to a tenant, because essential services mean you've got to have these to make these a habitable place. And so you can essentially say, hey, the place wasn't habitable, and if I can't live there, I shouldn't have to pay rent. You can also get substitute housing and charge the landlord the difference of cost. So if I have to go to an extended stay hotel because the landlord isn't providing hot and cold water, or the toilets don't work, then I can charge the landlord the difference between what it cost me to stay at the hotel and what it would have cost me to live at the place. The tenant must give written notice that there's a problem. And then you're foregoing the right to terminate the lease on 10 days notice. So basically it's kind of an either or situation. Again, now if the landlord just simply doesn't fix the problem, then obviously you're going to go back to your previous remedies of just calling the lease over with. Landlord's use of self-help. Landlord is not allowed to use self-help. Just cannot do it. And this happens all the time, or I won't say all the time, but it happens very often. There's a problem with a tenant, and the tenant may be completely in the wrong. Tenant may be not paying their rent. Tenant may be having loud parties till 3 a.m. Tenant may be doing these things, but landlord cannot engage in self-help. That means locking out, going in, throwing people's possessions in the yard, or throwing it in a storage unit, or what have you, cutting off utilities, things like that. That gives the tenant an opportunity to sue for 1 1/2 times actual damage, or to recover possession of the property. Or the tenant can simply just sue to terminate the lease. Or actually wouldn't even need to sue. The lease can just be considered terminated at that point. I believe that may cover our issues. So yes, so again, I want to thank you for your time and attention, and hopefully if you have run into these issues, this video has been of some help to you.
All right. Nice work.
Good enough for government work?
Yep. Excellent. Now go rest.
I will do that. I got to do a couple more things before I can do that for sure. But yes,
Get out and enjoy the sunshine.
I will do that. Thank you.
Okay, thanks so much,
Talk to
Charles.
you
I
soon.
appreciate it. And I'll be
No problem.
sending these to Sarah to post on PBTA, and then we'll share them on our YouTube channel too for staff. So
Okay, very cool. If you can again, can just let me know how long the recording was. Shoot me an email or something.
yep, once it takes a little while to process. So yeah, I can let you know. Okay. All right, thanks. Enjoy the rest of the week.
Bye.
Bye.